Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more contents related to Steno. This dictation is only dictated for aspirants who are preparing for JW exam. So be ready for the dictation. It is admitted case that the petitioner had applied for allotment of a flat in the above mentioned scheme stop. The normal procedure of allotment of a flat has been prescribed in 1979 Regulation Stop. Regulation 34 in equivocal/unequivocal terms says that a plot building shall be allotted by a lottery drawn publicly. Stop. It has also been mentioned in the same regulation that all the applicants shall be sent written information regarding the place, date and time of the lottery, and such information shall be made public by publishing the same in newspapers and promulgation through other similar sources. Stop. It is the admitted case of the petitioner that she did not participate in the draw made through lottery and that her name and the disputed flat were kept segregated. Stop. The main contention of the petitioner is that since the housing commissioner kept her name and the disputed accommodation out of the draw of lottery, it means that the disputed flat was allotted to her, and the housing commissioner and the respondent number 1 are bound under law to approve its allotment in her favor. Stop. It is her further contention that the segregation process by itself means that the respondent number 1 as well as the housing commissioner have decided that, keeping in view her request, the said flat was allotted to her, and giving an approval of the same is nothing more than a formality. Stop. This contention has been vehemently opposed by the official respondents. Stop. They have categorically stated that there were few more applications pending before the housing commissioner regarding the same flat, and after due consideration the housing commissioner took the decision that this flat should be exchanged by flat number L410, which was allotted through lottery to private respondents. Stop. Stanza. Learned counsel for the petitioner, Shri Satish Chaturvedi, has argued that since the flat in question was segregated for allotment in favor of the petitioner awaiting formal approval of the same, the flat in question stood allotted in her favor. Stop. It has further submitted that the decision taken by the Housing Commissioner on 2012-2006 to segregate the flat from normal mode of allotment, and the fact that the application of the petitioner was kept out of lottery draw simply means that the Parishad had actually allotted the same in favor of the petitioner. Stop. It has been further submitted by Mr. Chaturvedi that the allotment of the disputed flat in favor of the respondent oblig private respondents is bad, as it was done under the orders of the respondent number 3, who did not have any authority to pass such an order. Stop. It has also been argued from the side of the petitioner that due to her difficulties and genuine need, the petitioner had requested the Chief Minister of UP for allotment of the particular flat, which was duly considered by him, and in this background the commissioner exercised his power in favor of the petitioner. Stop. Para. In our opinion, this argument does not have any force. Stop. From the perusal of Regulation 48, it is evident that the law has given certain powers to the Housing Commissioner, keeping in view certain unforeseen contingencies and difficulties which may arise any time before the Parishad. Stop. It may be true that the petitioner is living separately from her husband since long, but she has the capacity to purchase a HIG flat in the metropolitan city of Kanpur, which indicates her reasonably good financial status also. Stop. Therefore, one cannot say that she is a poor lady having no means. Stop. From the records, it is evident that the husband of her real sister is the Provident Fund Commissioner of Uttarakhand state who had approached the officers of the Parishad with request that the disputed accommodation be allotted to the petitioner. Stop. It is also clear from the records that in the event of the death of the petitioner, her sister, who is the wife of the Provident Fund Commissioner, will be her nominee. Stop. This by itself shows her good relationship with the sister, who is the wife of a very senior officer of a state, and therefore it is clear that the petitioner does not belong to the weaker section of the society. Stop. Stanza. The facts arising out of the present writ petition are that on the basis of advertisement made by the respondent in the year 1989 for the purpose of appointment on the post of constable, as the petitioner was fully eligible to be considered and appointed, he submitted relevant documents, and on the basis of aforesaid document, petitioner was considered, treating his date of birth as 15th November 1969. Stop. The high school certificate issued by the Board of High School and Intermediate of the year 1983 was submitted at that time. Stop. Petitioner on the basis of aforesaid appointment was working, and the conduct of the petitioner was always appreciated by the relevant authority from time to time. Stop. It appears that on the basis of some complaint regarding various persons who have obtained the appointment, claiming themselves to be dependent of the employees working in the department under the dying in harness rules, some investigation was made without any notice to the petitioner, and it was found as alleged by the petitioner is entered as 15/11/1965. Stop. Though in the certificate which has been submitted by the petitioner, the date of birth is recorded as 15/11/1969. Stop. Para. The contention of the petitioner to this effect is that in case on the basis of some complaint, if the respondent was of the opinion that on the basis of some inquiry made thereunder the certificate submitted by the petitioner was having some discrepancy or wrong date of birth according to respondent is entered, the petitioner was entitled to have a show cause notice and opportunity. Stop. The appointment of the petitioner cannot be cancelled without any notice and opportunity, that too after completion of about 17 years of service in the police department. Stop. In case the petitioner would have been given a liberty, he would have submitted a certificate issued by the high school board which was submitted at the time of entrance of his service. Stop. Without any notice and opportunity to the petitioner, the order impugned dated 22/2/2008 cannot be passed. Stop. The petitioner has placed reliance upon a judgment of Apex Court reported in 1991 SCC 330 Sharvan Kumar Jha and others versus State of Bihar and others. Stop. On the strength of the aforesaid decision, learned counsel for the petitioner submits that in case on the basis of some inquiry it was found by the respondents that certificate submitted by the petitioner is not correct, or they have come to the conclusion that it is a forged certificate, the principle of natural justice has to be observed, and no order can be passed without any opportunity to the petitioner. Stop. The division bench of this court has also held that termination without any show cause notice or opportunity to defend has been held to be violative to the principle of natural justice and has quashed the order of termination. Stop. In Dipti Prakash Banerjee versus Stender Nath Bose National Center for Basic Sciences, Calcutta, and others reported in 1999 3 SCC 60, the Apex Court has held that if finding has been arrived at an inquiry as to the misconduct behind the back of the office without a regular departmental inquiry, the same is not permissible on the allegation of fraud without any notice and opportunity. The order passed by the respondent is in violation of Rule 8 and 14 of the UP Police Officers of Subordinate Rank (Punishment and Appeal) Rules 1991. Stop.